Hi everyone, the next defence that we're looking at for defamation is the defence of absolute privilege. This defence applies where particular government proceedings or court proceedings are underway and documents are produced as part of that or words are said. So a defamatory matter happens during a parliamentary or court proceeding effectively. These are occasions where free expression is considered so important that all publications are protected, even if the defendant is acting maliciously or was motivated by malice, as we say in law. This is because these types of communications are considered essential for the effective discharge of public functions, and it is considered important that those speaking to Parliament or those going to court not be forced to censor themselves for fear of defamation proceedings. Section 27 of the Defamation Act sets out what proceedings and what processes are covered by absolute privilege. So the first is parliamentary bodies. Proceedings of a parliamentary body, Australian court or an Australian tribunal are covered, and they but not when the same information is stated outside of those proceedings. So if someone in Parliament said something defamatory about me, I couldn't sue. But if the same person comes outside Parliament to a gathering of press on the steps, for example, and says exactly the same words in exactly the same building, but not during the parliamentary process, rather as something completely separate to that, then in those circumstances, that matter is not covered by the defence of absolute privilege. That's why you see that classic dare in Parliament, I dare the honourable member to repeat these comments outside of this chamber. That's basically saying, what you're saying to me is defamatory, and if you said it outside of Parliament, I would sue you for it. There are both Common Law and Defamation Act provisions for absolute privilege or defences of absolute privilege. We've pasted them here side by side so you can see the similarities and the differences. So at common law, judges had looked at things such as the English Bill of Rights, where it said that freedom of speech and debates or proceedings of Parliament ought not to be impeached or questioned in any court or place out of Parliament. And that was in the case of Gibson McAlone. And as far back as the 1800s. Similarly, most states have made legislation about this, like the Defamation Act Section 27 provision that I mentioned previously. That section says it's a defence to the publication of defamatory matter if the defendant proves that it was published on an occasion of absolute privilege. And then it says without limiting subsection 1, so without limiting what is absolute privilege, it then goes on and sets out some circumstances where you absolutely do have absolute privilege. And so you see there the proceedings of a parliamentary body, including but not limited to producing documents, etc. to that body. And then they also include proceedings of an Australian court or tribunal. And that means a court or tribunal established by or under law of an Australian jurisdiction. So any of the Australian states and any of the Australian and the Commonwealth, so any of their courts or any of their tribunals. And there's a similar rule at common law under the Royal Aquarium and Summer and Water Garden Society and Parkinson. So that means that whatever is said in court, you can't be sued for defamation. So if someone gives evidence in court and says something which would otherwise be defamatory, you can't sue them. If a judge makes a finding that reduces someone's reputation, and that's of course being published by being stated to everyone in the court, that also is not capable of being part of an action for defamation. And similarly, if the lawyers say anything or anyone in court who is part of that court proceeding says something or does something as part of that proceeding, they are protected under this law of absolute privilege. If you look at section 27.2, it makes it clear that if the categories can be expanded, and says it can do so in Schedule 1. Note that we don't actually have a Schedule 1, there's no content for that in the Queensland Act, but interestingly, the New South Wales Act has, which is on the same terms, has included additional bodies that are covered by absolute privilege, including their ombudsman and other administrative bodies. So have a look in theirs if you're curious, but do note that we haven't yet set out specific categories other than courts and parliament and tribunals. So that's it for absolute privilege. It basically acts as a complete blanket. It doesn't matter what the defendant's motive was for making the statements in parliament. What matters to the courts is that there is an overarching policy at common law that these types of speech must be protected because there are higher public considerations than suing someone for defamation. And the legislature has recognised that in the Act.